Okay. Good evening, everybody. This is a very interesting and an important topic that we have chosen to have today. And thank you, everybody, for joining this Law and Society Alliance's event this evening. Today we are having a very important guest who will be discussing a very hot topic of discussion that's happening in the country today. Uh, Today we'll be discussing about this sedition law in India and the debate that is happening between the national security and the democracy issues. And we have Sri Satyapal Jain here today. But before I introduce introduce the guest of the evening, I would like to just introduce the subject of the day, just to set the context. And I leave the floor to Sri Satyapal Jain ji to deliver his lecture. Which is quite important and a hot topic, as I said earlier. I'm sure you all know that the Supreme Court of India on May 11th put on hold the sedition law in India under Section 124A of the Indian Penal Code, and has ordered that no new case under this legal provision would be registered in India till it's being reviewed by the Government of India. And the Government of India has been provided time to review this law. Those who are already in prison today under this particular provision, who are under trial for sedition, they have been asked to approach the local courts for any relief that they may seek based on this current order of the Supreme Court of India. However, this relief does not apply to those who are charged with other law combined with the sedition law, such as the Unlawful Activities Prevention Act, which are basically terror-related cases and such. Thus, the sedition law has become a matter of debate among all sections of the society, particularly those who are really interested in national security affairs and people who are interested in legal affairs. This has become a major topic of discussion and interest. There are several questions that this particular development, based on the Supreme Court's order, has brought to the minds of the citizens of the country. And today we are actually trying to seek and find some answers to those questions. Sedition provisions in the Penal Code, as some of you might know, was introduced in 1870 during the British rule by Macaulay to perpetuate the colonial rule in India of the Britishers. But post-independence, this provision has been included in the Indian Penal Code for ensuring certain issues like national security, sovereignty and integrity, and to stop any fissiparous tendencies that might arise, in some parts of the country, considering that India is under constant attack, through a proxy war, to get some parts of India to break away from it. However, Section 144A of the IPC, which deals with sedition, talks of displeasure against the Government of India, to loosely paraphrase the legal provisions of this particular section. This comes directly under the teeth of the principles of democracy which India follows, by which an opposition to the government by any political organization which is also competing to come to power is encouraged. The sedition law would also go against the freedom of expression provisions under the fundamental rights guaranteed by the Indian Constitution's Article 19(1)(a). Of course, there are reasonable restrictions to this fundamental right under Article 19(2). Which covers national security, sovereignty and integrity, diplomatic relations between friendly nations, inciting of offense against the state, and such other restrictions that are imposed by the article. This is precisely why the national security versus democracy debate over the sedition law in India needs to be understood better. And who else is better suited to make us understand this debate better than Sri Satyapal Jain? Sri Satyapal Jain is currently the Additional Solicitor General of India at Chandigarh and is a member of the Law Commission of India. He is a senior advocate practicing at the Supreme Court of India at Delhi and at the Punjab and Haryana High Court in Chandigarh. He is a two-term member of Lok Sabha in the 11th House in 1996 and the 12th House in 1998. He has had a long career as a practicing advocate and also as a politician. He was among the politically active youths of India who were put behind bars for standing up for democracy during the emergency years in the mid-1970s. Thus is the ideal public intellectual to be addressing the sedition law debate that is now raging in our country. And that is precisely why we invited him to deliver this lecture today. But before I ask Sri Satyapal Jain, sir, to deliver his lecture, here are some administrative announcements for the better conduct of this event. We shall be taking a few questions from the participants at the end of his lecture. And hence, I request the participants to type out their questions in the chat box that is available on the WebEx platform. And based on the relevance of the topic and based on the relevance of the question, and also on the availability of time, we will be taking up each of these questions. I'll be asking the questions on your behalf to Satyapal Jain ji. I also request the participants to keep their microphones on off mode so that there is no disturbance during the lecture. This lecture is being recorded so that it can be shared among the public, to the larger public. So there should be no background disturbances that happen during this recording. That's why I'm requesting that you please keep your microphones off, except for the speaker of the day, so that we are able to hear him clearly and also we are able to record this session much more clearly. Without much ado, I now hand over the floor to Sri Satyapal Jain Saab to deliver his lecture for the day. Sir, the floor is yours.
Thank you very much, Mr. Nipendraji. I am very grateful to you and to your entire team who have decided to give me an opportunity to share my perception of the so-called sedition law with you, and then also enter into some sort of discussion with the participants so that their doubts and my doubts are cleared and we exchange our ideas on this topic, sedition law. This sedition law, of course, is on the law book for a very long time and has also drawn the attention of the courts in a number of cases. But this came to the limelight, I will use those words, came to the limelight and became a matter of debate when during the last 1-2 years, some of the prominent personalities, maybe in journalism, maybe in film industry, maybe in public life, they were booked under section 124A of the Act. They applied for bail, somewhere bail granted, not granted, High Court, Supreme Court, as is the usual with the court procedure. But some of them were very important personalities of the media also. Some were very important in the film industry also. So during the last 2-3 years, this issue started getting the attention of the media, the public, the lawyers, and the legal fraternity. And climax was reached when a few days back, the Honorable Supreme Court of India, while examining the validity of Section 124A of the Indian Penal Code, passed certain interim orders. As Bhupendra was just now saying, what are those interim orders? No further cases will be booked. All those cases which have been booked, they can apply for bail. And the section itself has been held to be held in abeyance. These are very, very, did I say, from my point of view, surprising orders which have been passed by the Supreme Court. But the Honorable Supreme Court has the power to pass those orders. Now, what is sedition law? As a matter of fact, there is no separate law which you call as this sedition law. It is the interpretation of Section 124A of the Indian Penal Code, which is called as the sedition law. This was visualized in 1860, but later on brought to the law book on 1870. And it has been in operation in India right from for a very, very long time. Not that its validity was not challenged. Not that the validity is being challenged for the first time now. Its validity was challenged, and I will come to that a little later. 124A visualizes a situation. It was meant for those people who want to incite violence or public disorder against the government. The government doesn't mean that if you want to speak against the government, you disagree with the policies of the government, you say, no, this policy is wrong, I don't agree with you, I don't want you to remain in power, in the coming elections we will overthrow you, no problem at all. If you say your policies have brought the nation to such a situation that people are doing this, whatever it is, the criticism of the government is not sedition. It doesn't fall under the sedition law. That has been the situation from the very beginning. But Now, after certain cases, and because of this plain language of 124A, some people try to give it an interpretation that if you speak something against the government, if you do something against the government, then it will amount to sedition law. It's not the position like that. This issue came up for consideration, sedition law. What is the language? 124A. Whoever by words, either spoken or written, or by signs, or by visible representation, or otherwise, brings or attempts to bring hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India, shall be punished with imprisonment for life, to which fine may be added, or with imprisonment and so and so. There are two explanations to that. They are also very important. Comments expressing disapprobation of the measures of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offense under this section. So first, dilution of the earlier clause is there in explanation 2. Then explanation 3. Comments expressing disapprobation of the administrative or other action of the government without exciting or attempting to excite hatred, contempt, or disaffection do not constitute an offense under this section. Now, this issue came up for consideration before the Allahabad High Court, which declared it to be unconstitutional, invalid. The matter went to Supreme Court. This Supreme Court, 5 judges bench of the Honorable Supreme Court, in the case which is popularly known as Kedarnath Singh's case, in that case, the 5 judges bench of the Supreme Court, Kedarnath Singh versus State of Bihar, State of Uttar Pradesh versus Muhammad Ishq Ilmi, etc., etc. The 5 judges bench, we call the Constitution bench, examined the validity of this clause, is law, sedition law. So 5 judges bench, I'm repeating it, which is a Constitution bench, they examined the validity, constitutional validity of this clause, and I'll say they modified it. They interpreted it in such a way that the scope for its misuse or abuse or using it for the political opponents was diluted quite considerably. The Kedarnath Singh's case, paragraph 27, Supreme Court diluted it and says what will be the actions that will bring you under the sedition law. Inverted commas, I'll quote from there. In our opinion, applied to the case in hand insofar as we propose to limit its operation only to such activities as come within the ambit of the observations of the federal court, that is to say, now the important, activities involving incitement to violence or intention or tendency to create public disorder or cause disturbance of public peace. So therefore, let's not misinterpret it. Let us not misunderstand it. Let us not misquote it. Only 4 activities. Activities involving incitement to violence, intention or tendency to create public disorder, or cause disturbance of public peace. So these are the 3 situations which you, if you create, you will be caught by the sedition law. And here also I like to make it a difference, very clear. No country, no system, maybe even dictatorships, maybe democratic countries, maybe semi-government, multi-party, same party democratic systems. No government worth the name can tolerate an activity which creates violence for the purpose of disturbing, for the purpose of bringing into hatred, or for the purpose of public disorder in any country. And if you do that, you put the system into peril. You cannot do it. Any nation has to subvert, any nation has to suppress such activities with strong hands. Otherwise, system will be brought to jeopardy at any time by any sort of people. In this case, the sedition law matter, the Kedarnath Singh's case, while upholding the validity, they said yes, if these conditions are there, then it will fall under sedition law. Simplicity of criticizing the government will not be there. Secondly, when it talks of government, let's be very clear about that. it talks about the government as an institution. Doesn't talk of the individuals holding the position in the government. If you say criticize the present prime minister or the chief minister or the former prime minister, future prime minister, any person who is acting as the as the head of the state, this law doesn't stop you from that. But if you want to incite violence, public disorder, that will amount to sedition law as per the judgment of this court, and no country can tolerate that. So we have to distinguish between the state, between the government and the individuals holding the position in the government. This law talks of the upholding sovereignty and integrity of India, the institution of the government, the nation, not only of the persons who are holding that position. Let's be very clear about it. There have been certain examples. People have quoted them, some journalists, some other prominent people. Look here, in that case, it was misused. The point which I'm trying to make now is this. If you start questioning the validity of any law or striking down the validity of any law only on the ground that this law has been misused, or there is a scope for misusing it or abusing it, it should be struck down. As a lawyer, I can tell you, if you start striking down these laws only on the ground that either it has been misused or there is a chance of misusing it, I can say with full confidence, with full command at my command, full respect for the constitutional laws at my command, it will be very difficult to uphold many of the laws that are in operation. Any law you see, because of this simple reason, two reasons. Why? Because of the simple two reasons that number one, the laws are put into practice. The people are booked under various offenses, not by the Parliament of India, not by the Government of India, not by the Attorney General, Solicitor General. Any commission of any offense is booked by a ASI or SI or an SHO at the police station. It is who he apply his mind, and after going into the facts of the case, he decides which section will be applicable, and according own perception, his own vision, his own concept, he will book you under a particular clause. Number one. Number two, so far as the misuse part is concerned, that is not confined to any particular government. In India, the law is implemented, law and order is the state subject. Maybe West Bengal, maybe Maharashtra, maybe Punjab, maybe Haryana, anywhere. The cases are booked in the states. So you can't blame the central government that you are misusing it, you are abusing it. Second principle of criminal jurisprudence is also equally important while examining any law. As per the criminal jurisprudence, if there is a doubt that you have committed a particular crime, you will be booked. Some murder has taken place. There is some evidence, there is a doubt that you have committed it. You will be booked. And after the trial, 4 years, 5 years, 6 years, 2 years, whatever it is found that no, there is a doubt whether you committed this offense or not. You will be acquitted. So the basic jurisprudence of at all. But this principle that merely because there is a doubt you will be booked and merely there is a doubt you will be ultimately acquitted. This, I think, time has come to see that this principle is also reviewed at a particular time and we come out with some solid solution to this problem. Now, the allegation of abuse and misuse of the section. My reply to that is, first I said that if you start, this is no ground to strike down any law, any validity of any law, only on the ground that there is an apprehension or it has been misused. Secondly, people say, what is the guarantee it will not be misused in future? It's a very pertinent question. I will reply two things onto that. Number one, there is a Lakshman Rekha in section 124A itself now. And what is the Lakshman Rekha? The Lakshman Rekha is, while criticizing the government, so long as you are within the Lakshman Rekha, meaning thereby you are criticizing it, you want the government to be changed, you want this government to go, new government to come, you are differing with the economic policies, you are differing with the social policies, you are differing with the functioning of the government, according to you, there is a corruption. To say that nobody can touch you under sedition law for that purpose. But the moment you try to cross the Lakshman Rekha, and what is that? The moment you say your government is not good, I don't agree with your government, therefore all people come together, take weapons, take out your pistols, revolvers, take out your weapons, let us overthrow this government and bring a new government in power, you are crossing the Lakshman Rekha. The moment you incite people to come on the roads, you incite people to disturb the public order, like we have seen in a number of cases in the various states in the country now, you are crossing the Lakshman Rekha of the sedition law. So therefore, public disorder, violence, tendency or inciting, all these things, so long as you do not cross that Rekha, you are within the law, no problem. But moment you cross that, you are crossing the Lakshman Rekha, and as per Kedarnath Singh's case, then you can be booked under section 124A, sedition law, which we ordinarily call it. Second, people say, while doubting what will happen, it will be misused and it will be abused. I have already said that in India, I don't think there is any state government or any other agency against whom there have not been any allegation of abuse of the power. Maybe PMLA, maybe ED, maybe CBI, maybe 302 murder, attempt to murder, all those laws which we can visualize, you cannot say that there have been no allegation against that. Simpliciter, because there is an apprehension, it can't be misused. Second, I feel, and you will agree with me, the biggest guarantee against the abuse, misuse of any law in India is the Indian judiciary. Indian judiciary has stood the test of time. In many cases, in many cases where in many cases where the law doesn't even permit you to grant bail, the courts have been granting bail. Certain offences where there is no ground, the courts have been quashing the FIRs. We have seen a number of cases. The biggest guarantee against any abuse or misuse of the law is the Indian judiciary. And I have been giving not one, but many examples of the independence of the Indian judiciary, which are rare in the entire world. First, it is only Indian judiciary in the entire world which set aside the election of the sitting Prime Minister of India in 1975. In the entire world history, there will not be a parallel example where the election as a member of the parliament of any sitting prime minister was ever set aside. And when the matter went to Supreme Court, it's a different matter. The Indian parliament amended the law, and because of the amendment only, the appeal was allowed and the judgment was set aside. So I'm saying first guarantee is the first example which I'm giving, Mrs. Gandhi's case. Number two, the Indian parliament very rarely passed an act which was called as National Judicial Appointment Commission Act. All members of parliament, 900, about 900, belonging to all political parties, BJP, Congress, CPM, CPI, TDK, MDK, all parties put together, both houses passed that act unanimously. Unanimously. Here in sedition law, there can be two views. Somebody may be in favor, somebody may be against it. But that act was passed unanimously. 5 judges bench of the Honorable Supreme Court with a ratio 4-1. One of the Honorable judges said it's okay. 4 said no, it's violative of the basic Constitution of India. Though in the entire Constitution, this basic structure has not been used anywhere. The Constitution doesn't define what is the basic structure. Nowhere. It is only by way of the judicial interpretation that it has been done. So I say the Indian judiciary stands guarantee against not only the violation of these small provisions, but even against the constitutional mandate. If the judiciary feels it is against the basic structure, it can strike down even that also. Why can't the Honorable Supreme Court or the High Court or judiciary take care of any case of abuse or misuse under section 124A, which is a very comparatively not to that level to which was the constitutional amendment. Now, recently, nowadays, we are discussing another case, Mr. Navjot Sidhu's case. One may agree, one may not agree. One may say he's innocent, somebody may say he's not. But I'm giving this example. The incident happens in 1978. 34 years after the incident of the offense, passing through the trial court, session court, high court, Supreme Court, though delay has been there. But Indian judiciary's hands are enough, strong enough, long enough to reach any person, even after 34 years of independence. If a person who was a minister, who was an MP, who was the president of the party, a famous cricketer, he couldn't escape the rigor of the Section 307, or he couldn't save himself from the clutches of the judiciary. After 34 years, the man had to go to jail because the Supreme Court said, no, your offense is such, you have to undergo the punishment. Do you think this judiciary will allow the police or the prosecution to prosecute people under 124A without any guarantee, without any checking, without any action taken against them? And another example, last example of these four I'm giving, Rajiv Gandhi ji was assassinated in May 91. There were certain convictions of certain people. I'm not going into merits of that. Murder, assassination of any leader is as bad as anything could be. Maybe of any party leader, it has to be condemned. And in fact, Section 124 also talks of inciting violence against the state. It is Indian judiciary. Even the assassins who murdered him have been released after 34 years, after they have undergone their sentence. These four examples, I can give number of examples on that. Elections were set aside, people were sent to behind the bars after this. And so these are the issues which guarantees that the action or the section or all these clauses are applied in a right manner, proper manner. There is no use, there is no misuse. One thing let's not forget, the Indian criminal law is such, the Indian system is such, unfortunately, because of two things: paucity of judges in the courts, increasing the number of cases in the courts, that you are not able to get hearing of your case within reasonable time. A judge has 100, 150 cases every day. I'm not blaming anybody. I'm not blaming the judiciary, nor I'm blaming those who are appointing the judges. But what I'm saying is this, that there are certain reasons for that, that justice ordinarily is getting delayed. For that, even the Law Commission, even the Judges Conference, Chief Justices Conference are trying to find way outs, how to increase the number of judges, how to increase the number of disposal so that cases are disposed of earlier. But because of the system as such, sometimes there is a delay. And it's a fact, we know it very well. As a lawyer, I can say, everybody will agree with me, there have been a number of cases in almost all the laws of society where innocent people had to suffer for 2 years, about 6 months, 7 months in the jails without no fault of theirs. I remember a former Chief Justice of our High Court, when he went as a judge to other High Court, he said that a case came to me, which was a case of acquittal of a murder convict, but he had gone about 12 years of sentence already in jail. When I went through his file, I found that this man needs acquittal. Ultimately, we had to acquit him. And you can imagine the plight of the person who has undergone 10 years, 12 years in jail, ultimately is acquitted. So you cannot, the point I'm trying to make is, you cannot isolate the cases under Section 124A from the trial of other cases under different laws. There also there is an abuse. There also there is a delay in deciding the cases. There also there is a delay in acquittal or conviction. So simplicity saying that there is a delay, it is no ground for the laws to be struck down. I am of the view. Now the Supreme Court has, on the request of the government or the request of the Supreme Court, Government of India has agreed to reconsider and re-examine this clause. My view is this clause must remain on the law book. On the law book, it must remain. But let's lay down the parameters, the criteria as to which are the cases which will fall under sedition, which will not fall under the sedition law. Because of the reason, as I said earlier in the very beginning, these laws are applied not by the people sitting in high position, by a ASI, by a SHO, by a constable. You can imagine a person sitting in a remote area. What will be his understanding of law? He will just read the IPC and try to fit in the offense anywhere that he deems fit. So therefore, number one, when the Government of India is reconsidering, Shri Narendra Modi ji has shown that magnanimity. Let's now have a relook at that. Let's lay down the parameteria, the criteria, precautions, apprehensions, all under this law to bring it in black and white that these are the cases which will be considered to be under the mischief of sedition law. Other cases will not be there. Number two, as they have been suggested by the Government of India, before the Supreme Court. We can even go to this extent that if such type of case comes, there is a complaint of sedition law against any person, it may not be simply seated taken by the ASI or the SHO. Let it be examined by a IPS officer so that he knows the law. He knows Kedarnath Singh's case. Everybody may not be able to even understand Kedarnath Singh's case. Everybody may not be even able to understand the implication of 124A. So therefore, these are 3-4 suggestions which are coming, which must be kept in mind. And when the government is examining it, I think we should all, who are in the legal fraternity, who are the lawyers or lawyers in making, or students, or even otherwise interested in the jurisprudence of the giving justice delivery system, should come out with these suggestions. Let's not simply stop at criticizing it. No, it's anti-democracy, it must go. No. What are the suggestions that you are giving? Let's give the suggestion to the committee which has been formed. Let us go to them. Let us tell them that these are the things that we are suggesting. We will like you to examine it so that we come out to a concrete situation where all apprehensions are removed, all chances of misuse are removed, and we go to a system where the law can be implemented. Now, let's not forget a distinction between the state and the government. Rashtra or Raj. Rashtra, nation. Raj is the people who are ruling it. भीष्म पितामह जब उन्होंने महाभारत में अंत में अपने प्राण त्यागे, तो आप कभी उनकी वो भाषण सुनिएगा जो उन्होंने 10-12 मिनट भगवान कृष्ण के सामने दिया। उन्होंने कहा कि देखिए, मेरे से जीवन में एक गलती हो गई, मेरी कमिटमेंट हस्तिनापुर के साथ थी, हस्तिनापुर के राष्ट्र के साथ थी, लेकिन मैं उसको हस्तिनापुर के राजघराने के साथ जोड़ बैठा। अगर मेरी कमिटमेंट हस्तिनापुर के राजघराने की बजाय हस्तिनापुर से होती तो मैं द्रौपदी के चीरहरण में चुप नहीं रहता था, मुझे चुप नहीं रहना चाहिए। तो उन्होंने माना मेरी गलती थी। तो आज हम जो ये इसकी सेडिशन लॉ की बात कर रहे हैं, इट इज नॉट अगेंस्ट द पीपल हु आर इन पावर, इट इज एन ऑफेंस अगेंस्ट द स्टेट, अगेंस्ट द नेशन, अगेंस्ट द इंस्टीट्यूशन ऑफ द गवर्नमेंट। हमें उसको डिफेंड करना है, हमें उसको बचाना है, उसको बात करनी है। मैं आखिर में एक बात और कहना चाहूंगा। भारत के संविधान में 1975 में कुछ अमेंडमेंट्स हुई थी। मैं तो 23 साल की एज में आई वाज इन जेल बिकॉज आई वाज सपोर्टिंग जयप्रकाश नारायण मूवमेंट. I was arrested by the then government. Anyhow, that was the situation at that time. A chapter was added in Indian Constitution of India, and a section, Article 51A, was added. Right now, we have been talking till now about the fundamental rights. This is a chapter 51A, fundamental duties of a citizen. These are 11 duties which we all expected to follow. I will read only 3 which are relevant for the debate that we are entering into now. To abide by the Constitution and respect its ideals and institutions, the national flag and the national anthem. I think it is our duty, first duty, to respect by the Constitution as well as all our national symbols. To uphold and protect the sovereignty, unity and integrity of India. Sedition law talks of only punishing those people who incite violence, who create public disorder with a view to disintegrate the country, which is against the unity and sovereignty of the country. To safeguard public property and to adjourn violence. This also basically is taken care of by 124A, because these are the fundamental 3 duties which, if you violate, though these duties are not enforceable, then ultimately you go for committing an offense under 124A. Now, democracy is equally important as the sedition law, and any sedition law is as equal as the democracy. There is no conflict, there is no contradiction between the two. To save the democracy, there must be sedition law, and the sedition law must be applied with a view to preserve the democratic structure of the country. You have to reconcile between the two. There is no contradiction, because in a democracy, you have a right to overthrow the government by not violence, but by the ballot. Not by bullet, but by ballot. You have a right to do that. You are within democratic symbols. You criticize the government, bring a no confidence motion against the government within the democratic working, within the democratic principles and democratic setup. But the moment you cross that Lakshman Rekha, as I pointed out earlier, then you are not only violating the vigor of sedition law, you are against the democracy also. The moment you say, if we will overthrow the government Bharat tere tukde honge, inshallah, inshallah, and you incite people to indulge in violence, then you can't claim you are a democratic. If you say no, I don't agree with this comment, you are democratic. Within the reasonable time, if you do that, I feel that that will be saving the democracy, protecting the democracy, for protecting the unity, integrity of the nation, which is very important for any democratic working. I think the sedition law is a must. We apply it, we go to applying for it, we continue with this law on the paper book, law book, but with all the precautions as much as possible, so that this law is not misused, this law is not abused, and if there have been certain examples, we come out of it. The Honorable Supreme Court has now kept it in abeyance, meaning thereby for 2 months, no new cases will be booked under sedition law. Though one may have difference of opinion, one may differ with the concept and the order, but still I feel Supreme Court is the highest judicial authority of the country. They have the power to pass any order that they deem fit. Order has been passed. Let's wait for 2 months. In July, the Government of India will come out with its own perceptive, its own perception, its own plan, its own suggestions, and we also all can contribute to that, and so that whatever our apprehension in our minds are removed, and whatever suggestion we have, we can give it to the government and the Supreme Court, so that we come out, make our democratic more vibrating, more strong, and less cases of sedition as much as we can, because nobody wants. Some people say the conviction rate under the sedition law is less, cases are increasing. Friends, in any civilized society, that day will perhaps never come, but everybody wish, let's assume a day when there is no offense under any law, not even sedition law, not even murder, not even rape, not even theft and all that. But unfortunately, that day doesn't come. Human beings are such. Some or the other offense takes place here and there. And Indian Penal Code is I think, the best product of any human brain, which has visualized all sort of offenses, crimes that any human being can commit, which provide for the classification of all such offenses. Let us come out of that and proceed for a situation where Indian democracy is the best democracy which already is there in the entire world, and any exploitation of any law is reduced to the minimal. I am grateful to you for giving me the time. I had said I will take about half an hour. I think I have taken 34 minutes. Now I will be very happy to answer questions to the best of my ability and capacity, if any questions are put to me.
Thank you very much, Jain Saab, for this eloquent, putting it threadbare on the issue of sedition laws in India. And thank you for that. It was quite, clarifying for most of the participants who are advocates, who are lawyers, who are legal practitioners, and probably law students are also here today. So thank you so much for that. And in fact, while you were making your closing remarks, you almost, anticipated the sort of questions that are going to be coming, and and you answered them. So, like the senior advocate that you are. So what is the mind of the court? So you were able to judge that. So thank you so much for that. In fact, this question about low convictions that you actually mentioned, I'll start off the question so that I will allow time for the participants to pose.
താല്പര്യം വേണ്ട ഇത് ഞാൻ എടുത്തിട്ട് ആര് എന്തിത് ബിന്ദു സുരേഷിനെ ഇവിടെ കാണുന്നുണ്ട് ഇവിടെ
I'm a Punjabi. I can't understand this language.
I'm extremely sorry for that. I think somebody.
No problem. It happens.
Yeah, extremely sorry for that. Yeah. So the question is regarding this low conviction that you mentioned. That but low conviction doesn't justify the abrogation of a particular law. What is your opinion on that? So that is a question that I want to start off with.
Low conviction rate is not at all a ground to strike down any law. The low conviction rate can be for many reasons. Number one, the prosecuting agency, whether the prosecuting agency has taken the case seriously, whether they have investigated the matter properly, they have collected the evidence or not, because courts are the courts of evidence. They are, with all respect, they are not the courts of justice. They are the courts of law, evidence. Even if you have committed a murder, but there is no evidence, the court has no option except to acquit you. And if you have not done anything, still there is evidence which indicates that you have done it, you will be convicted by the court, because courts go by the evidence. sometimes the prosecuting agencies do not collect evidence properly, reasonably. Third, see, people who are being booked under the sedition law are very important people. Most of them are big people. They enjoy vast influence over the witnesses, the police, and everybody. I'm not accusing any person. I may not be misunderstood. But you have seen in India that the more important people you are, the more important person you are, the conviction rate is otherwise also very less. Now, the Ashwini Upadhyay's case, the Supreme Court has started requesting the high courts to expedite the cases against the MPs, MLAs, sitting MPs, even ex-MPs, ex-MLAs. And the courts are finding it difficult to what should I say, increase or accelerate the process of conviction or trial because of many reasons. They have the capacity to engage a very, very senior lawyer who will find out one flaw in the charge sheet, or he will find one flaw in the section or the evidence and all that. Go to the High Court, Supreme Court, get the stay of the further proceedings, which continue for years together. By that time, the witnesses have gone and all those people have done. But at the same time, I feel that low conviction is a matter of concern. It's not only in the sedition law, it is many other laws also. The conviction rate is low. Let us re-examine the criminal law and come out with a suggestion so that the conviction, I will not use the word conviction, I will say the decision is taken at an early date. और हिंदी में बोलते हैं ना, जो दोषी है उसको छोड़े नहीं, जो निर्दोष है उसको छेड़े नहीं. निर्दोष को छेड़े नहीं, दोषी को छोड़े नहीं. If we proceed in that direction, I think many problems can be solved.
Yeah, thank you so much for that clarification. There is also another question that this was a law that was brought during the colonial era. Because it was a law that was brought by the British and we are continuing to follow that, this needs to be abrogated to just get out of the colonial hangover. Is that a valid argument? What's your opinion on that?
See, if you have a list of all Indian laws that are in operation in India at the moment, you will find most of them were enacted during the British rule. Many clauses were acting during the British rule. So simply cited because it was a act it was a clause which was added by the Britishers is no ground to strike it down. It's no ground to strike it down. You study the 1935 Government of India Act, you study many other things, IPC, other clauses also of the IPC. When were they enacted? When were they added? And if you start dropping only because of the ground that it was during that rule, once again, I can say, I don't know how many laws you will have to drop. So this is no ground. But at the same time, keeping in view the Indian situation, Indian realities, and the Indian system of delivering justice, time has come when we re-examine the whole thing and we come out with these suggestions, maybe amendment to the 124A, maybe the new interpretation, and maybe new guidelines so that any chance of abuse, misuse is also reduced and conviction rate is also increased. I don't agree with that. That's whether the conviction rate is less or more is a different issue. But justice should be done. If justice has been done to the people, whether the conviction rate is less or not should not be an issue of that concern.
Yes, absolutely. I agree with you on that because there are a lot of other laws which are colonial laws. So they are working fine for India. So why not this one? Okay, there was another, particular issue that is, which I kind of gathered from your speech. You talked about the multi-party system in India, multi-party democracy in India. We have different governments in different states ruled by different political parties which don't see eye to eye with, with the central government. The central government doesn't see eye to eye with some parties, political parties that are ruling, in the state. This kind of, there are various pulls and pressures that happen as far as Indian democracy is concerned. Do you think that is a good guarantee for? I mean, I think I'm stating the obvious. In your opinion, do you think it is a good guarantee for ensuring that these kind of misuse of law doesn't really happen? Because I'm sure even states which are not seeing eye to eye with the party that is in power in the center will be forced to use these laws against this particular party workers who are protesting, say, in a particular state which is not ruled by them. So, I mean, I understand. I think you're getting the drift of my question.
Yes.
So, yeah.
India is a multi-party democracy. We have parties in the state. We have parties at the center. National parties. There are 4, 5, 6 national parties. then there are 4, 6, 5 state party in every state, and there have been alliances. The national party fighting with the state party in the state, but aligning with them at the center. United Front government, most of the parties which formed an alliance, they were otherwise in conflict or in clash with those parties in the respective states. But I think that is the beauty of Indian democracy. We have multi-party system. Every party has to take oath. Every party is confined and they are committed to the Indian constitution. Every party has its own propaganda, its own target, its own agenda, its own mission and all that. And let's not forget that when you apply sedition law, then sedition law is applied not by the state government. I said earlier, it is by the people at the lower level. And allegation of misuse have been not only against the party, against the government, which is ruled only by one party. Maharashtra is not BJP, UP is BJP, West Bengal is not BJP, it is TMC. So therefore, this exploitation at the lower level, I think, have nothing to do with the multi-party system. Rather, multi-party system is a guarantee, and the internal working of every political party is also a guarantee that if there is any instance of any use, misuse, or abuse, then people point it out. And the most important guarantee to my mind nowadays, next to the judiciary, is the freedom of media. The moment you do something at a lower level, before even person is arrested, media will reach there. They will highlight on the national channels. Look here, not citing this example either way, nor in his favor or against him. Aryan's case. The boy is arrested later, but the media is reporting that at the all national levels, channels, before he even goes to the police station or before the jail. That gives a chance. That gives a chance to all the agencies, to all the people, governments, police officers, judiciary, to think about that. And the moment you apply your mind, the law says if you apply your mind, you will always reach a correct conclusion, correct decision. And therefore, I think it's a guarantee against any abuse or misuse of the law.
Right. We don't have much question. There is one question from one of
yes,
our...
Yes, no problem. Any question?
Yeah, I mean, there is one question from one of the participants, but it's not quite relevant to the topic that we are discussing.
कोई बात नहीं, बताइए, अगर हो सकता तो जवाब दूं.
Okay. Okay. The question comes from Dr. Nishta, who is from the Central University of Punjab. He's actually asking, can the legal system evolve in a way in which a beginning is made for the fusion of civil and military relations? Can we not probably have an umbrella of such laws which can help restrict this hybrid warfare? Basically, this is quite relevant to the defense.
I will request her, whatever you want, whatever your suggestion, you please send in writing in short, 1 or 2 page note, 2-3 paragraphs. We will examine that. And in case we feel that, yes, it needs consideration, I'll forward it to the concerned quarters. But first, you be clear about it and bring it in black and white in writing as to what do you want.
Yeah. What I'm going to do is I'm going to just post my the Law and Society Alliance's email ID on the chat box.
Yes.
Those who have any queries that you want to post to
you can send
it.
Any suggestion for improvement is always welcome. Whatever you want to say, please send in writing so that we can forward it to the concerned quarters.
Absolutely. So I'll forward it to Sri Jain Saab and we'll get a reply to you for your question on that. So I'll take one last question before we end the program. We have another 10 minutes to go. There is you did mention about some incidents that have been happening in the country in the last few years, some protests that are, including the January 26 protest of the farmers. There was a year-long farmers protest that took place. Of course, it was non-violent except for the January 26th incident. There was a CAA protest that happened. Of course, it didn't turn violent, but you saw some Delhi riots that took place. So, I mean, these are all a lot of incidents that keep, where does the, the seditious activity, I mean, I think there is a very thin line that differentiates a seditious activity to a activity which, which is valid under the democratic process. So where do we draw the line? That will be my last question, and with that we'll end the session.
देखिए, मैंने जैसे शुरू में भी कहा, अपने लेक्चर में कहा, सेडिशन लॉ में लक्ष्मण रेखा है. There is a लक्ष्मण रेखा in sedition law, and the लक्ष्मण रेखा is the moment you indulge in violence, incite people for indulging in violence or public disorder, you fall within the sedition law. the moment you simply criticize the government, you are not within the mischief of sedition law. Balwant Singh's case. In Balwant Singh's case, after the Supreme Court, after the assassination of Srimati Indira Gandhi, Mr. Balwant Singh raised slogans, Khalistan Zindabad, Raj Karega Khalsa and all that. He was booked under sedition law. But this matter went to Supreme Court. Supreme Court said no. He did not incite violence. There was no violence after that. He simply uttered certain slogans, which he at that time might have done. It may be violation of any other law, but you cannot call it that it's a mischief under the sedition law, because neither he incited violence nor was there actually any violence after that. I think that is the biggest guarantee. So far as the Kisan agitation, CA agitation is concerned, मैं जो बात कहने लगा हूं वो मेरा व्यक्तिगत मत है, पर्सनल मेरा मत है, और मेरा मत यह है कि आज समय आ गया है कि हमें ऐसा कानून बनाना पड़ेगा अपना विरोध प्रकट करने के लिए, टू लॉन्च योर प्रोटेस्ट अगेंस्ट द गवर्नमेंट, अगेंस्ट द सिस्टम. ये जो रूटीन बन गई है, कोई भी व्यक्ति 10 आदमी, 50 आदमी, 100 आदमी, 5,000, 10,000 आके रेलवे लाइन पर बैठ जाएंगे, सड़क पर बैठ जाएंगे, कोर्ट के सामने बैठ जाएंगे, ट्रेन को रोक लेंगे, जहाज को रोक लेंगे, गाड़ियों को रोक लेंगे. इस पर सख्ती के साथ अंकुश लगाना पड़ेगा. You have to put an end to all these activities with an iron hand. You don't imagine the plight of those people who suffer because of this. मुझे मालूम है किसान एजुकेशन के कारण चंडीगढ़ से जो दिल्ली लोग जाते थे, जो 5 घंटे की ड्राइव है वो 7-8 घंटे भी लगते थे. ट्रेनें रुकी रही. कोई माँ अपने 2 बच्चों के साथ स्टेशन पर आई है, अपने घर जाना है, पीछे से आ गई है, ट्रेन नहीं है, 1 दिन 2 दिन, या ट्रेन चली रास्ते में रुक गई, 2-2 दिन ट्रेन नहीं चल रही. What will happen to that? You just come on the road and gherao the road because your something wrong has been done with somebody in your village, and you don't allow the people to move. Somebody misses the flight, somebody is missing the interview, somebody is missing the hospital. There have been examples when you are taking people in an ambulance to a hospital, and because of dharna on the road, because of a dharna on the railway line, because of a blockade of a road, you are not able to take the patient to the hospital in time, and he dies during the way itself. I personally feel, whatever you may call the law, whatever you may give the name, but time has come that now you have to enact a law where blocking of roads, hospitals, railway tracks, educational institutions, public places should be treated as a very serious offense. You may protest anywhere you may like. In Chandigarh, they have provided a place. Sector 25 park has been provided. Go and protest there. Hold your dharna and pradarshan. But you cannot do it on public streets. You should not be allowed to do it on public road. You should not be allowed to do it on public trains and all that. I think time has come to enact that law. But these are my personal views. I should not be misunderstood to having said anything on behalf of the government.
Right, absolutely. You are very clear on that. Thank you so much. Of course, it's a very critical issue. It's being debated by everybody who are concerned about democracy and national security in India. Both the sides have different views, but I think you brought out that balance between what is to be done by the people, by the government, by the judiciary, and of course there are checkpoints which ensures that misuse doesn't happen. In such cases. Thank you so much for enlightening us on this subject, and I really thank you for
honor and listening to me, whatever knowledge I had about the law.
No,
thank
please,
you.
It's a
always at your
thank you so much.
Yes, Vipendra ji, always at your disposal whenever you call.
Thank you so much. With this, we will end this session. We'll come out with another event another day. And I thank Satyapal Jain ji for his time and for his wisdom. Thank you so much.
Thank you.